One of the angles of attack or approach for the Trump administration is to try to do a full court press, no pun intended, at the United States Supreme Court to try to pressure them into making rulings in their favor without a lot of time for reflection or deliberation. And the main way to do that is to try to use the shadow docket method, the emergency application method, which doesn't allow for oral argument in general, makes snap decisions within a very short, sometimes days amount of time with a very incomplete record having been developed below. And that Donald Trump believes is in his favor because he's already got 4 votes that he can reliably count on. And he's only got to pick up 1 more from the middle or from the right middle of Amy Coney Barrett and John Roberts. So we're watching now a dozen different petitions for emergency applications. They're not all emergencies. Most of them are not. It's just the strategy, and the Supreme Court majority is letting him do this. They've taken up 2 new petitions, one by Donald Trump on an emergency application so he can bounce transgender Americans from serving valiantly in our military, as they have done for the last 20 or 30 years. He wants them gone, and he wants the Supreme Court to allow him to do it during the pendency of the appeal. We have that. And then we've also got a petition related to coming out of another state, Montana, about whether, and the opponents of it, about whether parental consent is necessary under the Montana Constitution to allow for teenagers to get abortions. The fact that they're taking it up on an emergency application is not a great sign for that particular matter. We talk about it one place on YouTube that I know of, unprecedented, where Dina, Sayegh, and I sit here only on Legal AF at the intersection of law, politics, and the Supreme Court. Here's a clip. That's the other thing. We're coming into opinion season.
Mm-hmm.
This is right. This is end of April. We're going to start seeing a lot of opinions to close out the term in May.
Oh, absolutely.
You and I are going to have to do hot takes on a lot of them.
No, for sure.
Right? Yeah, it's going to be like every day. There's going to be 2 or 3. You and I are going to have. We're waiting on like 20 or 30 opinions. Then that's on top of the emergency applications that have to be briefed and ruled upon. So, listen, I don't think they don't have to get together and be on the bench. They can do this remotely, but
yeah,
a lot of them are going away. They go to like Europe for 6 weeks, and they go, they all get all expense paid trips about the law, and they write books. But they're going to have to come back because they're going to be getting these circulated petitions while they're away, and they're going to have to make rulings.
Absolutely.
But Donald Trump is going to try to take advantage of that.
Yeah.
Because the advantage for him that he's pressing of the emergency application docket, shadow docket route, is that it leaves no time for reflection. It leaves no time for caucusing. It leaves no time for lobbying among the Supreme Court justices, among each other, to reach a consensus conclusion and to flip and turn votes. That's what really happens when you read all the books that you and I have read that are required reading in law school, like The Brethren, going back to the 70s and 80s. That's what goes on behind the scenes. And that's how you fight for the hearts and minds of Amy Coney Barrett and Roberts. And you can flip a vote, hopefully, but you need time, and you need a process, and shadow docket doesn't allow for that.
No,
it doesn't allow for any face-to-face with some of these people. Will be like, hey, fill in the blank justice, let's take a walk and have a cup of coffee. A lot of things happen during this this deliberative process, but it's missing, and that's what Trump's banking on. He's banking on they go into their ideological reflexive corners on issues, and then he only has to fight for one of two, right? Because Roberts, Alito, Thomas, Kavanaugh, and Gorsuch are going to go off to the right quick on an emergency application. And Jackson, Kagan, and Sotomayor, they go left. And who's in the middle? Roberts and Amy Coney Barrett. And if you're on the right, you only need one of the two. So he figured out early on, this is the way to split the atom on things that matter. We've never had, when you and I went to law school, anybody went to law school, the cases that fill up our book on constitutional law, or however the tablet today, I guess, is filled with cases, and they're 99.9% of them are from the regular docket, the main a brief, 3 briefs, an oral argument, and a lot of deliberation. And that's how you make precedent. Not this thing.
No, it's true.
Drive-by rulings.
It's true.
And that's all we're talking about. You and
Yeah.
we're like exhausted from these drive-by rulings, right?
Yeah. And like you said, they don't give us enough, right, to even be able to justify their own legal opinions.
Exactly.
And we did have
or to guide the trial judges.
Yeah. We did have 2 oral arguments this week.
Okay, why don't
Do
you
you want me
touch
to
on
give
that?
a quick recap? Because this is where we did actually have a full-fleshed oral argument.
Yes.
One had to do with the ACA Preventative Task Force. We previewed both of these last week. And that one, it looks like the Supreme Court is going to allow the Preventative Task Force to continue to do its job.
What does that mean?
So
for people just joining this new.
Yeah. So essentially the argument was that the members of the board, the task force board, they argued were principal officers that needed to be appointed and confirmed by the Senate. Otherwise, it would be a violation of the appointments clause. And the government argument was, no, they are inferior officers because they have the Secretary of Human Health and Services has oversight. They're not independent. Essentially, what the groups, it was an extreme Christian group, was trying to stop them from giving preventative HIV care because they said it, quote, encouraged homosexuality. This is a case in 2025. It's crazy. But that was their argument. Supreme Court justices, pretty much across the majority of them, did not buy that argument. And I thought Justice Kagan kind of said something funny. It's like the Supreme Court humor, right? Every once in a while, they kind of say something funny, which is, we're not, she's like, usually we destroy independent agencies. We don't create them, which was funny. And kind of like a little preview of, right, what they're being asked to do with Trump. But they, even the more conservative justices like Kavanaugh or whatever was like, Congress knows how to write this if they want to create an independent agency. And they didn't. So we're not going to give them more power than Congress did.
Right. Yeah. And it's another example of like versions of the major issues doctrine, which, we're not going to if it's something major, we presume Congress knows how to put it in writing. Right. And if they're not going to put it in writing, we're not going to imply it from something else. And that's the other exit ramp that the Supreme Court justices use. Welcome back. That's the kind of content you can come to rely on here on this channel, Legal AF MTN. I do it in collaboration with the Midas Touch Network and the brothers over there. We formed it together right before the election. I curate the channel. I do a lot of content, but not alone. I've got another 10 or 11 contributors here, from Court Accountability Action to Shan Wu, Dina Dahl. I've got Dave Arenberg and Melba Pearson who have come over. I've got a couple of new contributors that join us this week coming up that I'm proud to announce. I'm going to wait another couple of days to tease it. And then after that, we got a brand new podcast that's going to be joining us as well. Send the message that you want this channel to succeed and you want to get reminders about its content. Hit the subscribe button. Until my next Unprecedented with Dina Sayegh Dahl, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event, by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. the Popok firm, fighting for your justice every step of the way.